Hello, everyone. So we're missing a few students. So we'll just kind of go over what we're going to do this week while we give them a few more minutes to log on. So this week we are going over lecture 5, which is the last lecture before your midterm. I apologize that next week is the week we are doing the paper workshops and having the guest lecture. So what we're going to do this week is go over the basics of criminal law. And then the following week, we will have 2 days of paper workshops. And then on Friday, we're going to have either 1 or 2 officers from Charleston Police Department come and give a guest lecture about some of the stuff that we learned last week with all the case law, specifically, how they do that stuff in practice. So today we need to start with Jeopardy. Let's see. Do we have Tristan? There's Tristan and Hunter. All right, you two are playing Jeopardy today. Do we have any questions before we get started? No questions? All right, well, Tristan and Hunter, if you guys want to turn your mics on, I'll get the quiz pulled up.
Can you hear me?
I can.
Okay.
All right, as soon as you know the answer, just shout it out and we will begin. Hunter?
Is that the one where the court ruled that you couldn't use evidence in court that was obtained without a warrant?
Yes. So I can't even tell who said that.
That was Hunter.
Okay. All right. Sorry. I can't see either of your mouths. I just see from here up. So it's hard for me to tell. Yes. So that is correct. I'll give you credit for that if that's what you wrote on your quiz. Really what we're looking for here is that this was the case that made that applicable to the state courts. So the one that said that you couldn't use evidence illegally obtained is probably Weeks versus US with the exclusionary rule. But remember, up until 1961, only the federal agents had to abide by that. Matt versus Ohio made that applicable to the state courts. So all police officers had to do that moving forward, but I will give you credit for that. That was Hunter, right?
Yes, ma'am.
Okay, very good. Okay.
Many people.
Where?
Yeah. Is that like, are you talking about like if you're at an airport, you drive into an airport and you can be searched?
So that would be the opposite of a reasonable
That'd be when
expectation.
you don't have privacy, but
Yes.
if you were reasonable, that would be like your home, right?
Yes, it would have to be your home though. It wouldn't be like if you were in somebody else's home, then you would not have a reasonable expectation of privacy. Okay. Which one of you said that?
Tristan.
Okay, there we go. Okay.
True.
Yes, was that Hunter?
Yes, ma'am.
Okay, very good.
Did he say true or false?
True.
He said true? Okay. That's what I thought too.
That one's no.
Yes, was that Hunter again?
Yes, ma'am.
Okay.
That was Hunter.
Okay, all right, so I will accept the answer no. I will also accept yes if you say no unless there was probable cause. So you're not supposed to move anything, but if you have probable cause to move something, like you see a trail of cocaine leading to a pile of something under a rug, then yes, you can lift the rug up, right? But otherwise, no. So I will accept either no or yes, but. All right, last one.
The right to remain silent.
Very good. Yes, Tristan. All right, close game. Hunter is our winner. You guys will both get a 5 out of 5 for playing. And I haven't graded those quizzes yet, so I'm going to try to do that a little bit later today. So I'll add Hunter and Tristan got a 5 for that. All right.
Okay, thank you.
You're welcome. Great job, guys. All right. Just give me 1 second. Let me pull up this week's lecture. So we're going to cover the super basics of criminal law. If you are interested in this stuff, you have 2 choices. 1, go to law school, but 2, Dr. Hefner teaches another criminal law course that covers this stuff more specifically. But we're just going to cover just some of the basics of criminal law this week. All right. So one other thing to note, your study guide is available in this week's module. If you would like to go ahead and start filling that out, it's just a bulleted list of terms. So I recommend taking your textbook, your notes, and your PowerPoint and putting all of the information that you can find underneath each bullet. And if you'd like to schedule a meeting with me, I'm happy to edit your study guide for you. I'll cross out things that you don't need. I'll fix something that's incorrect, help you find something that you can't find, and I'll give you major hints as to what the essay questions are going to be. But you have to schedule an appointment for me to do that. You can't just email me your study guide because it requires kind of like a one-on-one question answer sort of thing. All right, here we go. So conventional legal wisdom holds that the essence of a crime consists of 3 conjoined elements. The first one is the criminal act, which is legally referred to as actus reus. So anything criminal justice related, you're going to see a lot of Latin terms in here, a lot, especially when we're dealing with the law. There's a lot of Latin in there. So the first essence of a crime is 1, the criminal act, which we refer to as the actus reus. 2, the mens rea, which is the culpable or guilty state of mind. And 3, the concurrence of the 2 of them together. So we really don't have a crime unless there is a guilty act, a guilty mind, and those 2 together. However, there are 2 exceptions to that, which we're going to go over in 2 slides from now. But in general, in order for you to be considered, or what you have done to be considered criminal, you need to have done that criminal act, that actus reus, and have a guilty state of mind. And the third is those 2 together. So the actus reus refers to the actions of the person, so what this person actually did. And this is the necessary first feature of any crime. It is literally translated as guilty act in Latin. So there's an important distinction when we're talking about the actus reus. So to be something is not a crime, but to do something usually is. So for instance, someone is caught using drugs. They can be arrested for that. But if a police officer asks you if you have used drugs previously and you say yes, there's nothing they can do about it unless you are doing something else like causing a disturbance, right? Or they see you with some sort of paraphernalia. But if an officer asks if you have done drugs and you say yes, there's nothing that they can do about that. They would have to get you for like drunk and disorderly or, something like that. Or that might give them probable cause to search you and then find drugs or paraphernalia on you. But simply admitting that you have done drugs to a cop, now if you're driving, then we've got another problem there. But if you're walking down the street and you admit that, being drunk or being high on the street is not something that they can do anything about. So I'll give you a fun little story. When I was at USC, which is where I went to college, I was 19 years old and I was walking into a frat party when the cops showed up. And I had just gotten this very similar lecture in my Intro to Criminal Justice class. The cops stopped everybody and I had an empty red Solo cup in my hand. And they tried to arrest me. And I was like, well, what are you arresting me for? And they said, they wanted to arrest me for intent to drink, which is not a thing. I was like, you can't arrest me for an intent to drink. I'm not actually doing anything. And how do you know I'm not going to fill water in this cup? Long story short, they had to let me go because I wasn't doing anything. So to be something or to have the intent to drink is not a reason to arrest somebody. Simply holding a red Solo cup was nothing. All right, so mens rea. Actually, other side note, the cop that was kind of harassing me during that situation, about 5 years later was fired from the force for just being a complete asshole and harassing students and other people as well. So I didn't really feel that guilty about that. So we've got the actus reus, the guilty act. Number 2, we have the mens rea, which is the guilty mind. So this refers to the state of mind or criminal intent of a person. So did this person intend harm? Was it accidental? Was it negligent? Was it reckless? So mens rea translates to guilty mind, which refers to the defendant's state of mind at the time of the crime. That point right there cannot be overstated. So anytime you are dealing with, if somebody's trying to claim insanity as the reason why they did something, the defense attorney has to prove that they were insane at the time of the crime. So whenever we're talking about your guilty mind, your mens rea, we only care about when that crime was committed, what your state of mind was. If you were crazy after the crime, that doesn't mean anything. If you were crazy before the crime, that doesn't mean anything. We care about at that time of the crime.
Dr. Hill, I have a question.
What's up?
So if a defense was trying to use insanity as like a way to get a person off, if they brought up like past crimes that the person did but was never caught for, could they be charged for that crime?
Okay, so that's a common misconception that pleading not guilty by reason of insanity is going to get you off. It will not. Basically, what you're trying to do is remove some of that culpable state of mind, right? So we caught you doing the crime. What mens rea, what we care about, and we're going to talk more about this in the next slide, is how guilty are you because did you mean to do that? So generally, when somebody pleads not guilty by reason of insanity, instead of going to prison for life, they are going to a mental institution for life. So that's not getting them off. So your actual question was, if the defense attorney, are you asking if the prosecution can bring up other crimes that they did?
I'm saying, so like, for example, let's say, yes, he was insane at the time. He would come home and like lose his temper on his wife and always beat his wife or something like that. Would they then be able to like domestic violence type thing?
So most likely, yes. So it would probably be, so are you trying to, so I'm trying to think, the first question would be, would a judge let that in? Because generally that's not something that you would include unless it was part of your defense. So I don't know that a defense attorney would want to bring that up. That's not really good evidence that they're crazy. Really what you want is like a psychologist or a psychiatrist to indicate, or a record of being admitted to the hospital. But it's not going to look, you would be not a great defense attorney if you were like, look, my client is not guilty because he beats the shit out of his wife. Like, that's not going to look great to the jury. But if you're asking if they admit to other crimes under oath, can they then use that later? Yes, that is the question. That is possible. All right, so actus reus is the actual act, and mens rea is your state of mind. So your state of mind is usually what a prosecutor will determine as to whether they're going to charge you with like first degree, second degree, third degree, right? Or involuntary versus voluntary manslaughter. So that mens rea is usually the extent to how much time they're going to give you in prison. That's what we're using that mens rea for. And your defense attorney is usually trying to reduce your culpability to show that you are not as, you shouldn't be blamed as harshly for this crime because of your state of mind. So your mens rea is usually trying to determine if it's going to be, you know, first degree versus second degree. All right, so let's talk about the 4 types of mens rea. So these 4 types, the purposeful, intentional, knowing, reckless, or negligent, This is when we're talking about this stuff, usually we see words like these in the statutes to determine if somebody would be charged with first degree versus second degree versus third degree. Also, what you might find is these descriptions in the instructions to a jury. So anytime a jury is about to deliberate, the judge will give them instructions and say, if you are going to vote for first degree, this is what you had to, the threshold we're looking for, versus if you vote for second degree, this is the threshold we're looking for. So you're not going to see, purposeful homicide. You'll probably see first degree murder, right? Or you'll see like involuntary manslaughter might be, described as negligent, right? So what we're looking for here is just an understanding of these terms, and then within statutes and instructions to juries, that's how they're deciding how guilty you are. All right, so it's easiest to view this on a sliding scale, so we'll start with the most guilty, which is purposeful or intentional. So this means that whatever your intention was, that's what you did, right? If you set out to murder someone, very specific, and you murdered that person, that is purposeful or intentional. So this is an act that is undertaken to achieve a specific goal. So this is the most guilty. This would be your first degree murder right here. You attempted to murder this person and you did. That was your goal. That was your purpose. That was your intent. So if you looked up the South Carolina statute for first degree murder, you're going to see basically what we just described right here, and you might actually see the words purposeful or intentional within that. So the one that is slightly less guilty than purposeful or intentional is knowing mens rea. So this is behavior that is undertaken with awareness. So the rest of the knowing and reckless, it's easiest to understand them with examples. So I'll give you an example here. So for instance, let's talk about the difference between purposeful versus intentional, okay? Say you plant a bomb on a plane with the intent to kill one person, right? That was your intent. So when the bomb explodes, you kill all 100 people on the plane. So you are guilty of purposeful homicide by killing that one person that you were attempting to kill, but you are guilty of knowing by killing those other 99 people, because you know when you put a bomb on a plane and it explodes, everyone's going to die. Even though your intention was only to kill one person, you're guilty of knowing mens rea and knowing homicide by killing those other 99 people. So if you do something where you know for sure other people are going to be harmed, that's knowing mens rea. Even if that wasn't your intent, if your intent was to kill one person on a plane, but you kill everybody on the plane, you are guilty of intentional mens rea for that one person, but guilty of knowing mens rea for all those other people on the plane, because there's no scenario where everybody's not going to die when you put a bomb on a plane. So knowing means that you didn't intend to harm someone, but you knew the actions that you were taking were going to harm other people. So the next one is reckless mens rea. So this is behavior that increases the risk of harm. In this activity, the person may or may not have intended harm, but they should have known that this behavior could endanger others. So let's go back to this example of bomb on a plane, right? So you have the intent to kill one person on a plane. You find out what airline they're on, what day they're flying on, and the specific airline, but you don't know the time, right? So you plant a bomb and you set the timer to go off at 7 a.m. the bomb goes off and you kill a baggage handler. You are guilty of reckless mens rea, right? So it wasn't in your purview to know for sure that you would kill a baggage handler, but you knew that if you planted a bomb, someone was going to die. So you didn't purposefully kill the baggage handler because that was not your intent. You didn't knowingly kill him because it wasn't certain the baggage handler would die, but you were guilty of reckless mens rea because you knew someone would die. So knowing means that you know you were definitely going to kill other people, even though that isn't your intent. Reckless means you know someone will die, but you don't know who it was. Whereas knowing, you knew everybody on that plane was going to die. So negligent mens rea is the least guilty of them. So the difference here is that it's possible with your actions, someone may not die. So driving recklessly or drunk driving, right? That is, both of those are huge risks where someone could die, but it's not a guarantee. Whereas with purposeful, knowing, or reckless, someone's going to die, right? So with negligence, you're not aware of the specific risks, whereas with purposeful, knowing, and reckless, you know the specific risks, right? You plant a bomb, someone's going to die. You're just not reckless. You're not exactly sure that the person that you killed is definitely going to die. Knowing, you know other people are going to die, but it wasn't your intent to kill these other people. So negligent homicide, usually we see this as like involuntary manslaughter or vehicular manslaughter. Usually we'll see the term negligence somewhere within that description of the statute. All right. So remember how I said the general features of a crime require three things: the actus reus, the mens rea, and the concurrence of the two. Well, there are two exceptions to that. We have strict liability crimes and inchoate crimes. So a strict liability crime does not require mens rea, and an inchoate crime does not require actus reus. So let me explain. So some actions are considered criminal without the necessity of mens rea or criminal intent. And this is what we refer to as strict liability crimes, which means you are liable for punishment even if you didn't mean to do it. So even if you didn't have the guilty mind or the mens rea, you are still guilty if they catch you in the act. If you do the actus reus, regardless of if you meant to do it or not, you're still guilty. So this is the first exception to the essence of a crime principle. Strict liability offenses make it a crime simply to do certain things, even if the offender has no intention of violating the law. So a perfect example of this is speeding. If you've ever been driving down the interstate and you look down and you realize you're speeding and you didn't intend to do so, when the cop pulls you over, even if you tell him, I didn't mean to speed, he doesn't give a shit. That's a strict liability crime, right? They catch you speeding, even if you didn't intend to speed, you're getting a speeding ticket. So driving 65 miles an hour in a 55 mile an hour zone is illegal, even if you're still going with the flow of traffic. So even though you didn't intend to speed, you didn't even realize you were speeding, if they catch you speeding, you're still getting a speeding ticket. So the officers don't have to prove intent that you were intending to speed. They don't care about that because it's a strict liability crime. So another example of strict liability crime is statutory rape. So this occurs between two consenting individuals. It only requires that one of the offenders be under the age of legal consent. So even though it might appear consenting or that they are consenting, if you are under the legal age of consent, it's not possible for you to give consent because you don't understand what you're doing. So if you look up the statutes on statutory rape, they never mention anything about mens rea or a culpable state of mind. You simply have to be caught having sex with someone under the legal age of consent.
Excuse me, Dr. Hill.
Yeah.
I have a question about that. So like in South Carolina, the age of consent's like 16, right? But what happened? I'm pretty sure like it's still illegal for like a 16-year-old to have like consensual sex with a 19-year-old, right? Because they're still a minor.
So it depends on the when you say the legal age of consent to have sex, is that what you're saying?
Yes, ma'am.
Yeah, so if they are under the age of 16, they cannot. Once they hit 16, they have consent.
But like, I thought because they're still a minor, you still can't with the above an 18-year-old.
That wouldn't be statutory rape because it just has to. They might be charged with a different crime, but if we're talking about statutory rape, if they are under the legal age of consent, then that's all it takes.
Okay, I've always thought that it was like a weird like thing. Never mind.
Yeah, it's possible that there's a gray area. Prosecutors have a lot of discretion, and a lot of times they go with what the victim's family wants to do. But it's an example of a strict liability crime. And I have questions about this a lot. Like there's been several really famous cases where like someone has shown someone a fake ID showing that they are older than they say that they are, and they think that gets them off the hook, and it doesn't. That's just the way the law reads. It's just a question of kind of the prosecutors and the lawmakers are just kind of like, don't be having sex with somebody that might be too young to be having, that's kind of the way that they see it. You might have a case to reduce your mens rea, but they're still going to charge you with that crime if they want to move forward with that, even if the victim in this case was deceiving you in some way. All right, so that is a strict liability crime, and it's an exception to the essence of a crime principle because it does not require mens rea. You just have to be guilty of the act. So let's talk about inchoate crimes. So we've got more Latin in here. So inchoate means incomplete or partial in Latin. So what we have here is you cannot be convicted of a crime simply for thinking about doing it, which is what I learned when I was your age. I assume you guys are all around 19. That's how old I was when I told the officer that you cannot arrest me for intent to drink, right? And I was correct about that. But you can be guilty of an inchoate crime in which the crime goes beyond the intent or beyond the thought, but doesn't actually lead to a completed crime. So an inchoate crime is an exception to the essence of the crime principle, and that you don't actually need the actus reus. So strict liability is an exception. You don't need mens rea. You don't need a guilty state of mind. We just need to prove that you did it, the actus reus. And inchoate is the other side, right? We don't actually have to prove the act. We just have to prove the guilty state of mind. So the three most common inchoate crimes are solicitation, conspiracy, and attempt. So let's go through the three of them, and they are also easiest to understand on a sliding scale. So solicitation is farthest from the actual act of the crime, and attempt is closest to it. So starting with solicitation, this is the urging, requesting, or commanding of another to commit a crime, but it has to be specific and it has to be directed at an individual, okay? So this is going beyond the intent, right? You have the specifics and you're talking to someone directly, not just generally, right? So your example gives a really good example. A person who makes a remark to a general group of people, we should steal a car, has not satisfied solicitation. They haven't gone far enough, right? You have to be talking directly to someone with details. So I'd have to be talking to Aiden and saying, let's steal this specific car. There we have solicitation, right? But if I just say generally, we should steal a car, I haven't hit that threshold. That's just kind of an intent, but we haven't gone all the way to solicitation. So the most common solicitation that people know of is solicitation of a prostitute. So you have to be very careful how you do this. So when we send undercover cops in, they are always trying to get the prostitute to speak of prices, because that's what moves it towards solicitation, right? So as soon as she starts talking about money, that's when we can get her for that. But if she's just talking generally, and that's why prostitutes are often very cagey about discussing prices right away, because they don't want to be caught for solicitation. And it goes the other way as well, right? So if we're trying to catch a John, and the prostitute is being a little bit cagey, if the prostitute is an undercover cop and she's trying to get him to talk about prices and hand money over right away, that should be a red flag. Usually both parties are being very cagey to avoid the possibility of solicitation charges. So conspiracy goes a little bit further than solicitation. So when a person conspires to commit a crime, any action undertaken to further that conspiracy is generally regarded as sufficient basis for arrest and prosecution. So let me give you an example. So a woman conspires to kill her husband and may make a phone call to find a hitman, right? So the call itself is evidence of her intent and can result in imprisonment, right? We've hit solicitation, right? But so solicitation is just the idea directed at someone. Conspiracy takes it one step further. So we've gone past the vocalized idea into actually taking steps to have this crime committed. So if someone is hiring a hitman, right? So I'm trying to hire a hitman and I call someone specific and I give them details. I've hit solicitation. Now, if I then get them a gun, now we've gone beyond that idea and we've moved into conspiracy.
Dr. Hill, didn't that actually happen?
It happens all the time. Do you have a specific case in mind?
I swear I saw a YouTube video. It was like wife busted by undercover cop for trying to hire a hitman to kill her husband.
I know exactly what you're talking about. Yeah, that hit the news recently. Yep, she went beyond solicitation and he got details. He got her to give money. That's when money changes hands, we've got you for conspiracy. Yeah, I know exactly what, I think that was like, what, 4 or 5 months ago or something like that. It was all over the news, but yes. We have gone, those first couple of phone calls with details would have been enough for solicitation, but they were trying to get more out of her, trying to get her with conspiracy charges. So they went much further. And I believe she gave him money and a gun. And like, I think she had like written instructions of like where he was going to be with certain dates. Didn't look good for her. All right. So solicitation is very specific details vocalized to a specific person. Conspiracy is when we take steps beyond that. So the last one is attempt. So this is the last of the 3 inchoate crimes, and it's the closest to the actual commission of the crime. So an attempt to commit a crime, which occurs when an offender is unable to fully complete the intended crime. So it's somewhere between the conspiracy to commit the crime and actually committing the crime, the full completion of it. So if you intend to murder someone, but you just horribly maim them, then we've got attempted murder, right? So we've gone beyond solicitation, beyond conspiracy, the steps to do it, and something went wrong. They weren't able to actually complete it. So we've got them for attempt, right? So usually as soon as like you fire a bullet or, you try to strike them, something beyond actually the conspiracy, that's when they hit you with attempt. All right, questions about this before we start talking about the types of criminal defenses? All right. Okay, so we're going to talk about 4 different types of criminal offenses. So when a person is charged with a crime, typically they have some sort of defense. So a defense to a criminal charge consists of evidence and arguments offered by the defendant to show why they should not be liable for this criminal charge. So our legal system generally recognizes 4 categories of defenses. So alibi, which if shown to be valid, means that the defendant could not have committed the crime in question because they were somewhere else, usually with somewhere else at the time of the crime. So your book describes an alibi as a perfect defense. This is the only one in which the defendant is not admitting they committed the crime, right? So an alibi is saying, I am innocent because I didn't do it. All of the others are imperfect defenses, and they are saying, I did it, but I have less mens rea, and I should not be charged with the full extent of the crime, or I should be found innocent because of one of these reasons. So an alibi, we are looking for an outright acquittal. We're always looking for an acquittal, but an alibi, the only answer is an acquittal. It's the perfect defense because you're saying I didn't actually do it. Justifications, excuses, and procedural defenses are what we call imperfect defenses because they, instead of excusing them from all criminal liability, they're just saying, I deserve less, I'm not as guilty as somebody else because of one of these reasons. So the first of the imperfect defenses, these are known as justifications. So a defendant offers a justification as a defense. They are admitting that they committed the act in question, but they claim it was necessary to avoid some greater evil. So we're going to go through all 4 of these in extreme detail. But right now, I just kind of want to explain the differences between them. So justification is saying I did it, but if I hadn't done it, something worse would have happened. So the most ideal understanding of a justification is a self-defense, right? So I had to murder this person or they were going to murder me. So the next imperfect defense is an excuse. So someone who uses an excuse claims that some personal condition or circumstance at the time of the crime was such that they should not be held accountable under the law. So, not guilty by reason of insanity, that is an excuse. And the last category of defenses, they are known as procedural defenses. So these defenses are making the claim that the defendant was in some significant way discriminated against in the justice system, or that some important aspect of the official procedure was not properly followed in the investigation or the prosecution. So basically they're saying we shouldn't even be here because the other side cheated. That's kind of what they're saying, right? So prosecutorial misconduct is a good example of a procedural defense. But perhaps the most famous procedural defense was O.J. Simpson's defense, right? He was trying to make the claim that the police were racist against him. That's a perfect example of a procedural defense. All right, questions about these 4. We're going to do so much more details. alibi is pretty straightforward, but with justifications, we've got a bunch. We got a bunch of videos to watch. Excuses, we got a bunch. We got some videos. So many procedural defenses. So we're going to take our time with these, and we'll start on Wednesday with an alibi. All right? Any questions for me?
What are the 3 called again?
So we're talking, you mean imperfect defenses?
Yes, ma'am.
Yeah, so alibi is the perfect defense. It's the only one that says I didn't actually do it. Justification, excuse, and procedural said I did it, but I shouldn't be held accountable for one of these reasons. So a justification is I did it, but it was to avoid some greater evil. An excuse is saying I did it, but some condition at the time, like my insanity, I should be held less culpable. Procedural defenses is saying I may or may not have done it. That's kind of irrelevant. It's that something happened along the way that discriminated against this. All right. Other questions? Okay. So we'll leave here. We'll pick up on Wednesday with alibi, and then we'll start going through the other ones. We've got lots of videos to watch, including an excerpt from Law and Order, which is one of my favorite shows of all times. All right. If there's nothing else, I will see you guys on Wednesday.
I have a question.
Yep. What's up?
Did you get me for attendance when I was trying to join? Like my
Hey,
Zoom was not letting me join.
I don't do attendance. You guys are adults. You're paying to be here, you know. Do you need me to send you the lecture?
Yes, ma'am.
Okay, I can do that for you.
Thank you.
You're welcome. Have a good one.